right now, we've got Andrew McCarthy, former chief assistant U.S. attorney in the Southern District of New York, and now, of course, a Fox News contributor and writes at National Review. Andrew, thanks for joining us today on a busy day.
Larry, my pleasure.
Well, so I'm left kind of shrugging and looking up in the air saying, what exactly did the special counsel say today that we didn't already know from Bill Barr's summary of his report and the full report for that matter?
Well, I think I think it's a fair critique, Larry, that he didn't say anything that wasn't already in the report. But at the same time, the report is 448 pages. The statement he gave today was less than 10 minutes, and he clearly wanted to home in on a couple of things that he thought were important. And I think he did it the emphasis that he put on those things has really ensured that we're going to be talking about impeachment for the foreseeable future to come.
Yeah, let me play one of those things I think that you're referring to, and then you can expand on it, or at least a bit of it.
The special counsel's office is part of the Department of Justice, and by regulation, it was bound by that department policy. Charging the president with a crime was therefore not an option we could consider.
Now, first of all, was that specific to obstruction, or did that statement also encompass the Russian conspiracy meddling charges as well?
No, he only said that in the context of obstruction. And it's also a very disingenuous statement in that there's a difference between the question whether the Justice Department may charge obstruction and whether the prosecutor who is responsible for investigating the case has found a sufficient obstruction case. So to be clear, I hope, about this, it's the job of the prosecutor who's assigned to the investigation to make a decision about whether there's enough evidence to charge or not. Not whether to charge, but whether there's enough evidence to charge. That was his job. And then if he found that there was enough evidence to charge, Larry, it would be up to the Attorney General and the Justice Department as an institution to decide whether to invoke the OLC, the Office of Legal Counsel guidance that says you cannot indict or you may not indict a sitting president. Mueller's claim that the guidance about whether you can charge or not has to be factored into the question of whether there's a sufficient case or not is absurd. And I would point out that the guidance doesn't say that a president can never be indicted. It says that a sitting president, that is, the president cannot be indicted while he is in office. That means he can be indicted at some point, which means some prosecutor, namely the one who's been investigating it for 2 years, is supposed to make a decision about whether there's enough evidence to charge or not.
Right. And,
his failure to do that, I even after hearing him explain it today, I continue not to understand it. But, the fallout of his remarks today is that he didn't charge because of the OLC guidance, and therefore what he's telling Democrats is he may have found felony obstruction. And then the second half of what he says, the other important element is, in this system, the system we're in, it's not for federal prosecutors, it's for Congress to decide how to deal with the president's misconduct. So what he's basically saying is, look, I found a prosecutable obstruction case. I didn't bring it because of the OLC guidance. I leave it to you, Congress, because in this system you're supposed to deal with this anyway.
Well, did he explicitly say that, or are we just having to read the tea leaves and infer that from what he said?
Well, look, he didn't explicitly say it, but I mean, it's about as powerful an inference as,
all right,
the idea that the sun will come up tomorrow morning because it's come up every other day. I mean,
does it?
I can't tell you for sure it'll come up, but I'm pretty sure.
Is it in contradistinction to what Attorney General Bill Barr found, because he looked at the same evidence, he looked at the same body of work that Robert Mueller obviously has looked at, and he reached the conclusion, along with his Deputy Attorney General Rod Rosenstein, that there was not sufficient evidence to bring charges of obstruction, and he was not relying, was he, on the findings that you couldn't indict a sitting president?
No, the Attorney General made his findings, as I think the special counsel should have done. The Attorney General made his findings on the basis of the merits of the case as he saw it. But that, Larry, brings us to, yet another issue that I now think has to be resolved, which everyone has tried to sidestep up till this point. And that is, I think that Mueller and Barr had very different ideas about what the requirements are for an obstruction case, what the legal standards are for obstruction. Now, I think what the Attorney General tried to do in order to sidestep that question was to say, even though I disagree with Mueller on the law of obstruction, I'm going to accept his framework, his legal framework, because under these circumstances, even if he's right, there's no way a prosecutor could prove corrupt intent beyond a reasonable doubt. And therefore, we don't have to get into an argument about what kind of conduct can make out obstruction, because if you can't find intent, there's no case anyway, and I'm finding that there wasn't intent. From what I hear from Mueller today, there's a good argument that he disagrees with that. He didn't come out and say, yes, I found an indictable case, but what he did say was, virtually that. What he said is, if I had found the case that there was no case, as I did with collusion, I would have told you that. But I didn't tell you that. And the reason I didn't tell you that is because there's OLC guidance that says I can't indict.
Yeah. So we're speaking with Andrew McCarthy, former Chief Assistant U.S. State's Attorney, U.S. Attorney at the Southern District of New York, and we're talking about Robert Mueller's press conference. About an hour later, Senator Kamala Harris made this statement, Andy.
I think it's a fair inference from what we heard in that press conference that Bob Mueller was essentially referring impeachment to the United States Congress.
And that's basically what you have said as well. But here's my question. What do you mean inference that we're referring this to Congress for impeachment? Last time I checked, if he wanted to, he could have explicitly referred this to Congress for impeachment, couldn't he? Isn't that within his guidelines as a special counsel? No.
The special counsel, you're thinking, I think, Larry, of the independent counsel statute that Ken Starr operated under,
okay,
where you would be quite right. He would have to report to Congress. And that statute, by the way, not only called on you to decide whether there were prosecutable crimes, you also had to recommend to Congress whether there were impeachable offenses. When that independent counsel statute lapsed, what happened was the special counsel was created by regulation. And under those regulations, the special counsel is just a subordinate prosecutor in the Justice Department, like any U.S. attorney or actually any assistant U.S. attorney in the country.
I see.
And his job under the regulations was to provide a confidential report to the Attorney General that the Attorney General then decided to make public. But Mueller did not have any authority under the regulations to make a recommendation.
So it's bring charges or not, or recommend charges or not. So
right.
So which brings me back to this first question. If it's Robert Mueller's position, and the main takeaway today was that existing regulations and findings, legal findings, determine that you cannot bring charges against a sitting president, then what were we doing in the first place here? What was all of this about? Why did we need him?
Well, that's a very good question. I think that if how the president often says that if Jeff Sessions told me he was going to recuse himself, I wouldn't have given him the job in the first place.
Yeah.
I think if Mueller had told us that the position he was going to take was that the regulations didn't allow him to decide the one question we needed him to decide,
right?
They probably would have looked for somebody else to take the gig, right?
Right.
So, I agree with you that it seems to me to be a long, immortal waste of time to spend 2 years on this only to have the guy say the one thing you needed me to decide, I'm not deciding.
Well, and of course it's not over. It continues because it appears as though Jerry Nadler and other members of Congress want to walk down, as you said, Andy, the impeachment trail here. And that brings us to our this last portion that I found quite troubling. That Mr. Mueller, let me play it so everyone can hear it in case they didn't see the press conference. Here, listen along.
Now, I hope and expect this to be the only time that I will speak to you in this manner. I am making that decision myself. No one has told me whether I can or should testify or speak further about this matter. There has been discussion about an appearance before Congress. Any testimony from this office would not go beyond our report.
With all due respect to the special counsel who has a long and impressive history, is that his call to make? I mean, he's basically saying, I'm not accountable to Congress on any of this. Andrew McCarthy.
I'm sure he didn't mean to be as egomaniacal as that sounded, but that was very, very presumptuous. First of all, you're quite right. It's not his call whether he'll appear. And secondly, it's not his call what questions he'll answer, or to say that, you've now got the four corners of my report, I have nothing else to say. Can you imagine, let's say there was an appeal that arose out of his investigations, which I think did happen one or two times. In an appeal, what happens is you file a brief with the Court of Appeals, and then they bring you in for oral argument. Can you imagine if the first question from the court was something about, your position on this is, explain that to me. If you imagine if Mueller said, well, Judge, you have my brief. I don't have anything more to say.
Right.
I don't have anything more to I mean, good luck getting out of there with your head still attached if you try to pull that with a court. So, look, there's a lot of questions that are highly legitimate questions that can be asked of Mueller, not least, when did he decide that there was no collusion case? Why did he not issue an interim report? I think you would have gotten a lot better behavior out of the president from, say, the end of 2017 on. I'm not saying this is an excuse for bad behavior, but, if you had told the president that he wasn't a collusion suspect anymore after the end of 2017, I think this would have taken a lot of the steam and the pressure out of this investigation. It would have been good for the country. So why didn't he take that step? When did he decide that the OLC guidance meant that he couldn't even decide the sufficiency of the evidence of the case? I think,
those are all very good questions.
I can think a million questions to ask.
Absolutely. Very good questions. And I'm sure Adam Schiff has plenty of questions and Jerry Nadler have plenty of questions, but so would Mark Meadows and Jim Jordan. And that's the point. That's what we do here in this constitutional republic. Do you think that he will be subpoenaed? Do you think that he will finally be called to answer some of these questions?
I don't. I actually, at the moment, don't think so. Just because I think the Democrats only want him if he's a good witness for them, and what he did. Well, it's true.
I know.
Really, they can really. It's up to them really whether he comes in or not. And I think what he did for them today is better for them than they're likely to get if he's, on the hot seat answering questions.
What Mueller did for the Democrats today is actually better than facing questions and counter questions from Republicans.
Correct.
He gave them what they wanted.
Yep.
It's frustrating. And by the way, this means a lot coming from Andrew McCarthy because you have been incredibly respectful and patient with Robert Mueller and kind of given him a wide berth during this entire process.
Well, I don't mean to be disrespectful to him.
I'm not suggesting you're disrespectful.
I have a great deal of respect for and admiration for a lot that he's done in his career. On the other hand, if you get given one job to do and then you come back after 2 years and tell us I can't decide that one, then what do we need you for in the first place?
Exactly. It sort of lends a little credence to those of us who were saying, what are we doing here? Why we should stop this thing? All right, we'll leave it there. Andrew McCarthy, I know you're going to have a very busy day. I expect to see you all over Fox News tonight, so thanks for carving out some time for us.
Thanks, Larry.
That's Andrew McCarthy, former chief assistant, United States attorney for the Southern District of New York, and also a contributing editor over at our friends at National Review.